That's a really good question. What's the difference between constitutional law and what we're going to talk about in this discussion series? Constitutional law, or con law, as most folks in law school call it, at least we did, is in a nutshell what courts have made of the Constitution. It's what judges and lawyers and law school professors have made of it. It has nothing, or at least until originalism reared its ugly head in the 1970s, 1980s, very little to do with the actual history of the Constitution. That's why con law classes most of them start with Marbury versus Madison. It's the 1803 case that established, really for some invented, the authority of the Supreme Court to decide what's constitutional, the concept of judicial review. And even then, the court didn't use that authority because it only matters if the executive branch cooperates. That's still true, as we're seeing play out all too often. So from there, con law mostly deals with cases involving the Bill of Rights and later substantive amendments, so issues that had to be developed by the courts over time. Why? Because the original Constitution is silent about it. Why? Because Article 3, as was written by the geniuses in Philadelphia, didn't consider a judiciary, another branch, that would ever have to make decisions about those issues, about rights and liberties and freedoms. So that judiciary is actually kind of weak, the original Article 3. So their Article 3, gives the judiciary jurisdiction over cases arising under the Constitution. But what we have to think about is what that actually meant to the architects of the thing, Madison, Hamilton, and the boys in the band. And I'm not going to call them Federalists. That was their word for themselves. We will get into why that terminology is somewhat misleading. But they did not conceive of the courts as a co-equal branch. They rejected a Bill of Rights. I mean, at best, they thought that the individual rights were the state's problem, even if a couple of the states didn't even have their own Bill of Rights. That's a discussion that we'll get into. So that's why the resistance to that Constitution, the fight that resulted in the Bill of Rights, transformed the document in ways that Madison and Hamilton opposed, that they hated, and what they wanted to try to avoid. And how that fight redefined what the Constitution meant and what the courts would eventually do. Madison introduced the Bill of Rights in the first Federal Congress because he was forced to, not because he wanted to. And he thought that by controlling that amendment process, he could limit the damage to his perfect original document. So what is constitutional law? It's the body of decisions that have built up over time. It's Marbury, it's the slaughterhouse cases, it's Plessy versus Ferguson, it's Brown versus Board of Education, it's Roe versus Wade, Casey versus Planned Parenthood, and Trump versus the United States. And it's reading a lot of dissents, Harlan, Holmes, Ginsburg, and watching meaning shift through judicial interpretation. Now that's all really important, and that's all included in how we understand the Constitution, but it's not the same thing as the history of the Constitution. And it's definitely not public history. For that, we have to go bigger, we have to go deeper, and we have to make it useful. No theoretical abstract exercises for us, at least not in these discussions. And so that's what I hope that we're going to do, which is something else entirely. We're going to start with how you've come to understand what the Constitution is. And for a lot of people, there's already a baked-in narrative about that, right? It's a document created by founding geniuses that built the most extraordinary government that the world had ever known. 3 branches, checks and balances, power from the people, and rights protected for all, and the Federalist Papers that brilliantly explain everything. Except none of that's really true. So we begin by unpacking what we think we know now. Then we walk back into what it actually was. What it did, why it was written in the first place, and what it replaced. And for that, we have to go back to the world of Daniel Shays in 1786. And the country called the United States that was governed loosely by this thing called the Articles of Confederation. And in doing that, we can understand how the Constitution wasn't necessary. It wasn't inevitable. It was a political choice driven by a few people that was made in 1787. Folks who wanted to replace the admittedly messy decentralized local power of the Articles with a more centralized, aggressive, even chauvinistic, consolidated government. So we'll talk about that. We'll talk about the Philadelphia Convention, what it was and what it wasn't. We'll spend some decent time on the ratification process because it's critical to understand it. It's not just a set of vote. It is a series of battles, big ones. That's where the Bill of Rights comes from. It's a fight. And that's also where the mythology comes from. The framers, the Federalists, the architects were not national geniuses. The Federalist Papers were just one set of pamphlets among many. But later generations, lawyers, judges, politicians, elevated those texts to scripture. But it's really the laziest possible way to interpret the Constitution. Why did they use them? Because they supported the outcome that these later folks wanted. But that myth-making that elevates these folks into genius framers, that storytelling is part of the public history. Because it's the storytellers who always win. And all of that happened quickly in terms of the creation of the Constitution. In just, about 3 years, the foundations of the American Revolution were already being shifted. And so a new centralized authority was built on a new foundation, something different than what many Americans thought they had actually fought for in fighting for independence. And that's where we pick up the thread. So then we move forward slowly because the Constitution doesn't really change for the next 80 years. And we'll ask why. And then we'll look at what happens after the Civil War, how the 13th, 14th, and 15th Amendments rewrite the Constitution and take aim at the framers. And how for all that those amendments add, what they remove is just as important, such as the 3/5 clause. And how that terrified white people. Because even the enslaver architects knew slavery was wrong, but they chose to strengthen it because what did they fear more than anything else? A free black population. So even after emancipation, we see how courts, state legislatures, and white people move quickly to claw back the supremacy that they lost in those amendments, despite the Constitution, or more often, because of it. Jim Crow was constitutional. And that's all before we even get to the 20th century. So that's all part of the public history of the Constitution. What we get wrong, what we get right, how we got from then to now, and what it means to us today. And that's what we're going to be talking about. Hope you join along.